When the city decided to use the 2005 devastation as an opportunity to remake its criminal justice system, its leaders knew that jailing the largest percentage of people in any American city was not stopping crime. So they asked the nonprofit Vera Institute of Justice for help.
We need to be judicious in the use of detention and incarceration, always with the goal of improving public safety, right? There's a finite amount of dollars and human capital available to create a safe city.
Vera began the drive to use data to measure results. The Metropolitan Crime Commission weighed in too.
The police department was arresting an extraordinary number of people. In 2009, there were 59,000 arrests, but only 7,900 of those arrests were for felony offenses. So you're looking at 52,000 other arrests that were misdemeanor offenders. And many of those offenders, about a third of those offenders, were people that were arrested for out-of-parish traffic attachments.
So instead of hauling someone who'd failed to pay a traffic fine to jail, for the city to pay the sheriff a day rate for that prisoner, police were trained to use a summons instead of arrest. Later, the city council changed the law to allow the same police discretion for the most minor criminal offenses.
So these are the types of cases obstructing the public sidewalk or the like that really do not require incarceration. And rather than even beginning the detention period and then figuring out whether there should be a bond and oftentimes keeping a person in jail for weeks, the police made the decision to issue summonses in a much greater percentage of cases.
It's a 60 to a 90-minute event when you bring somebody to the lockup. What else went on in your beat area while you were gone? So absolutely it's an efficiency question, but I would never want a viewer to think that I thought that was more important than not making someone go to jail who doesn't really need to go.
The results, say the Metropolitan Crime Commission, about a 35% decline in total arrests since 2009, while felony arrests remain high.
We're seeing the police be more selective in who they're arresting and targeting and emphasizing felony offenses. We're seeing the district attorney's office work with the police department earlier in the investigation process to ensure that those felony arrests are translated into accepted felony cases and ultimately felony convictions. That can only be done through coordination and cooperation between police and prosecutors. That level of coordination and cooperation did not exist before Hurricane Katrina.
District Attorney Leon Cannizzaro sends members of his team out with police on every homicide scene, and that's just the beginning.
Rather than waiting 60, 90, or 120 days to get the report from that detective, we were meeting with the detectives less than 1 week after the crime occurred. We were sitting them down in our office. We were all sitting around at a table. We were talking with the assistant DAs, the investigators, the police detectives, and we were trying to build as strong a case as we possibly could.
His office prosecutes 85 to 90% of the cases police bring him, compared to the 50% rate the city used to see. And the decision to take a case or drop it is made faster. In crimes with no victims, the time between arrest and formal charge is much shorter.
So what we're seeing is a real short time period, for example, with misdemeanors, maybe a week to 10 days for the charging decision. And for possessory offenses and other low-level felonies, you're talking about 2 weeks as opposed to 45 and 60 days.
It stimulated a lot of thinking in both the DA's office and the police department about their processes. It automated a lot of their processes. With Police and Justice Foundation's help, we were able to get scanners in each of the police districts. So instead of driving police reports daily to the DA's office, taking up manpower, the officers would scan and email them regularly throughout the day. So that allowed for more careful data collections.
There are other new efficiencies at Criminal District Court.
What's happened now is that the Public Defender's Office and District Attorney's Office know that once an arrest has been made, they can begin discussions and they know what judge is going to be presiding over. The cases now are allotted based on the date of offense. So there is no waiting for the DA's office to accept a charge and then have it allotted to one of the 12 sections of court.
The allotment system is a lot more efficient. We know we can plot the course of a case from arrest, and that is very important because we get to move our resources faster and then have more predictability with our lawyers.
So that took the DA's office, the police department, the public defender's office, and the judges to all work together to solve a rather simple logistical problem that was costing the city a lot of money and was impeding the administration of justice in this parish.
But the biggest change at Tulane and Broad is the sole focus on felony cases since the DA moved state misdemeanors to municipal court. Cannizzaro says when he took office, he found 1,000 marijuana cases, about 1/3 of the docket, waiting to be tried at criminal district court.
But what we found was, by moving those cases to the municipal court, we found that the cases were moved quite expeditiously. The judges were disposing of those cases within a matter, 30 days, 60 days at the most, whereas we saw that those same cases were sitting on the dockets of the criminal court for as long as a year, 18 months, and it was just, there was no excuse or explanation for that. So by moving those cases, what we did was essentially free the judges up to concentrate their time and their efforts on the more serious offenses.
And we are hearing and seeing that there is a higher conviction rate that is happening over at criminal district court now. That would seem to be a real indicator that this is working.